response of the judiciary, it was, according to me, it was equally disappointing. Though the Act clearly applies to courts which are obviously included in the definition of public authorities, most high courts did not appoint even the public information officers, within the prescribed time. And many of them who appointed PIOs, framed rules which effectively deny the information to the citizens. I will give one sample of the Delhi High Court rule. The following information shall not be disclosed. Such information which is not in the public domain or does not relate to judicial functions and duties of the court and matters incidental and ancillary thereto. The rule means that no information will be given about the expenditure incurred by the High Court from public funds and about any appointments or transfers or about any recruitment. This was a totally violation of RT Act, where the disclosure can be withheld only on certain grounds specified in Section 8. No public authority can refuse to disclose information which does not fall under the exemptions permissible under Section 8 of the Act. It is reported, I am quoting the newspapers, that the former CJI recommended to the government that so far as the Supreme Court is concerned, the decision of the Registrar General of the Court should be final and not subject to any independent appeal to the Central Information Commission. It was reportedly recommended that the Chief Justice of India should have the unfettered right to interdict the disclosure of any information, which is, in his opinion, might compromise the independence of the judiciary. The former CJI had gone on record that even the disclosure of income and assets by judges or the formation of any independent disciplinary authority over judges would compromise the independence of the judiciary. Now, as Mr. Gonsalves told you, this issue is now referred to the larger bench yesterday, and I read in the newspapers that 19 high courts have responded that they would not prefer to be covered by the Right to Information Act. I don't have the exact response of the High Court, but it seems that this was in the context of the information relating to the elevations and transfers of the judges. Anyway, this is going by this, it is obvious that no information about the complaints against judges, about their incomes and assets would be available under the Right to Information Act. Thus, while the Supreme Court decrees that even candidates aspiring to become public servants like MLAs and MPs would be required to disclose their assets, when it comes to sitting judges, such disclosure would violate the independence of the judiciary. I may refer to the today's the reporting about the observations of Justice Karchu about the Allahabad High Court. And I do not wish to make any comment on the, but time has come that the judiciary has to be, the functioning of the judiciary has to be made more transparent. And it's not the issue of the compromising the judicial independence. In Subhash Chandra Agarwal's case, he said that the transparency would lead to more accountability, and ultimately it would enhance the image of the judiciary, and really the transparency and they should go hand in hand, the transparency and judicial accountability on the one hand, and the judicial independence on the other. Now, in this context, I may also refer to Subhash Chandra Agarwal's case. Now, there the question was, Mr. Subhash Chandra Agarwal's query was whether the judges of the Supreme Court have furnished the information about their assets to the CJI. There was a resolution passed by the Chief Justice's Conference in 1997 that all the judges of the Supreme Court and the High Courts will furnish information about their own assets, about the assets of their spouses and the dependent members. And the only query was whether such information was furnished. The stand taken by the registry of the Supreme Court was that the CJI doesn't fall within the purview of the RTI. finally this particular defense was given up, and several contentions were raised. Some of these, amongst other arguments, it was contended that the information sought related to subject matter which was an in-house exercise and thus could not be said to be held under the Act. It was also argued that the Code of Ethics formulated by Chief Justice's Conference, pursuant to which the asset information was published, had no binding force. These are all Code of Ethics or judicial conduct, standards of judicial conduct, which were laid down in the Chief Justice's Conference, and every judge is expected to follow this. But the stand taken was that it has only a moral force, it has no binding force. And ultimately this has led to the judicial standards and the accountability bill 10,000. That is likely to be introduced in this winter session, where this judicial standards or judicial code of ethics is made a part of the statute. So the argument was CPI was rejected, and it was held that there was a right to such information. The information emanated from an instrument which had not just moral force but had legal value. More importantly, the information requested under the application was not of such a nature which would compromise judicial independence. Now, pending these proceedings, the Supreme Court judges already published declare their assets on the website, Supreme Court website, and some of the high courts followed suit. The Delhi High Court and two other high courts published their judges' assets on the website. Now, I really don't know why should the independence of a judge be affected if his or her wealth is made public under the RTI Act. And what Mr. Falinariman said, I just would like to quote his words. If the credibility of the higher judiciary is to be restored, as I believe it must, since without the higher judiciary, our constitution simply cannot work, it is essential that every judge of the Supreme Court set an example and voluntarily make a public disclosure of his or her assets on the website of the Supreme Court, law or no law. This would then be dutifully followed by judges of the high courts on the salutary principles stated in Bhagavad Gita. Whatsoever great men do it, and the other men also do, the standard they set up by that the people go. So transparency, accountability, and efficiency are the pillars on which a judiciary rests in a democracy. In Subhash Chandra Bose's case, we quoted Edmund Burke. He said, all persons possessing a portion of power ought to be strongly and awfully impressed with an idea that they act in trust and they are to account for their conduct in that trust. With this, I come to some other objectives of the Act. And there are two aspects which really, which are very important. You see, it is necessary to expand the scope of public authorities liable to disclose this information. This should include political parties, religious and charitable organizations, NGOs and other private bodies performing functions of a public nature. For example, pharmaceutical companies, providers of health and education services, housing societies, the IT, the mobile phone companies. They provide these are all public services. So they should be included within the ambit of the RTI. Now, why this expansion is necessary? Because this increasing number of public functions are being performed by private bodies. It is imperative you remember all the days when the telephone and many other facilities, and even all this was in the government. Now, it is only health was mainly it was the government hospitals. Private sector has not grown so much in those times. But slowly it is now it's being shifted to the private players. So it's necessary that there has to be inclusion of those private bodies which are carrying public functions. Then secondly, it is necessary for the state agencies to take a proactive approach for implementing Section 4B of the Act. And according to me, this is the key of the Act. And even the Information Commission should be proactive. should insist for this implementation of 5 Section 4B of the Act. See, if you put this information in the public domain, there would not be much scope for the citizens to go to the Information Commission with their grievances. See, each department, whether it's a police station, whether it's a hospital, whether any other department, should have its own template. I mean, that template the information should be disclosed as per the template. For instance, in a hospital, a government hospital, or also a hospital which is supported by the government fund in some way. I mean, there has to be, or even a private hospital, they maintain their stocks in a particular way. So why it should not be disclosed on day-to-day basis? What is available, what is not available? All this information should be available to the public. So the posting of more and more information in the public domain should bring the great success to the very concept of Right to Information Act. With this, I come to the last subject which I would like to say, which I'd like to speak about, is the pendency before the accumulation of pendency before the state information commissions and some of the state information commissions and the CIC also. I immediately acknowledge that coming from judiciary, I have really no moral right to comment upon the pendency before the information commissions. I mean, judiciary is saddled with huge backlog. I appreciate that, but I feel that the strict timelines given by the Act are not being followed. And one of the main reasons which I feel that is really not sparing use or the non-use of Section 20. That is, according to me, this is the key to the success of the Act. India is one of the very few countries where the public officers are being penalized for not supplying the information. But this is perhaps the legislature realized how difficult it would be to extract information from Indian bureaucracy in the absence of such a penal clause. But the use of that penal clause is very necessary. See, if there is a delay, it's a duty. Why duty? The commission is statutorily bound to inquire into that case, issue a show cause to the public official concerned, and ask for explanation from him. And if that explanation doesn't disclose any circumstances within the parameter of Section 21, and there is no justification within the meaning of the section, the Information Commission has no option but to impose fine on the concerned official. And the fine should be computed from the date of the expiry of the period which is prescribed by the Act. In many commissions, I find that there is a